All right, we'll call this meeting of the Non-Civil Judiciary Committee to order. Want to take just a moment and recognize our judges of the week. Judge Tom Campbell's here with us. Judge, glad to have you. And State Court Judge is Judge Larry Mims from Tift County. See, we're glad to have you as well, Judge. And Judge Goss is with us. We got him. Good to see you, Judge. Representative Ralston has got another subcommittee to chair, I believe, so we're going to go ahead and call up his. Let's get through those. HB 323, I think, is the first on our list.
Mr. Chairman, I'm hearing motions.
Make it short and sweet.
Let me get my bills. First of all, it's a real honor to be back with chairman and members of this committee. I think actually I may have had 3 bills today. House Bill 323 came at the request of the Supreme Court. We actually considered this bill in this committee last year and passed it out, and it got lost in the trample crossover day or day 40, I'm not sure. But all it does in effect is give the Supreme Court a little bit of pressure on the death penalty cases by extending the time from 20 to 45 days for them to issue rulings. I think we have somebody, Deborah, we have somebody from the court.
This is Doug Blues, who works with the Supreme Court and handles those cases.
All right. Glad to have you.
And I'm sure he can answer any questions that I can't. So,
Okay.
very simple bill.
All right. Do any committee member have any questions for Representative Ralston on the bill? Okay. Don't see any. We've got from the district attorneys, David McDade is signed up to speak. Mr. McDade?
Mr. Chairman, we support the bill.
Sounds good. All right. If there's no further public comment, then we will now consider it in the committee. And I will recognize any member for a motion at this time. Representative Levitas.
I move to pass LC 149958, House Bill 323.
All right. We have a motion and a second. Are there any amendments or any discussion by committee members? All right. Hearing none, we will call the question. All those in favor signify by saying aye. Aye. All those opposed? All right, it passes unanimously. Okay, next we'll take up HB 549 and recognize Representative Ralston again.
Thank you very much, Mr. Chairman, members of the committee. I have with me on this bill Judge Ben Studdard from the Henry County State Court. I think actually he's here because he thought we were having a probation revocation hearing for Representative Lunsford. I understand. But he and I have worked on this bill all session, actually started working on it back last year, and all it does basically is streamline the jury, the sources of information available for jury list, and kind of brings DDS back into the hoop a little bit, and I would defer to Judge Studdard's comments. This came from, I can't remember the official name of the commission, but a group out of the Supreme Court and other places in the judiciary and some of the other agencies that have worked on this issue now for a year or two, as I understand it.
Actually, 5 or 6.
Okay.
Just,
Time flies when you're having fun.
yeah,
I
we've
mean.
had all kinds of fun, and yeah, I was actually here because we lost the signal on Mr. Lunsford's ankle monitor, and I needed to check on that.
Appreciate it.
Well, we
So y'all know where you cracking jokes. We're on the World Wide Web.
very good. Okay. Very good. Okay. We have a group that's been working through the Supreme Court, a committee on jury composition. That we're trying to streamline the process and use the data that's out there to automate the process of creating our jury boxes for all of our counties, which would save an awful lot of work on the county level among our jury commissioners and our clerks of court. Streamline government, reduce expense, and we've got all of the different members of the judicial branch, not only judges but court administrators and clerks, all working together on this project. Came up with this bill. We've sat down with folks from the Department of Driver Services. They're good with this language. They have this data. They can make it available to us. They're just concerned that they can't make it available to us without some express statutory authority that says so. So that's why we have the bill.
All right. Thank you, Judge. Okay. Any members have questions for Representative Ralston or Judge Studdard? Representative Lunsford.
Thank you, Mr. Chairman. At the appropriate time, I'd like to be recognized for a motion, considering the fact he happens to be my judge from my town.
Okay. We can do that. Does anyone,
Or one of them, anyway.
does anyone in the audience have any comment or want to speak on this bill? Okay. Seeing none, we'll recognize Representative Lunsford.
Make a motion. Do pass, Mr. Chairman, on House Bill 549, LC 342128.
Okay, we have a motion and a second. Do pass. Is there any discussion with the committee? Any amendments? Seeing none, call the previous question. All those in favor of passage of HB 549, LC 342128 will signify by saying aye. Any opposed? Okay. All right. We have a passage on HB 549.
Thank you very much.
And no, that's going to be the last one. HB 600 now.
I'll get her to do it too.
Thank you, Mr. Chairman. Tommy Floyd, is he back there somewhere? House Bill 600 comes to us, another Henry County angle.
I'm here to testify to Mr. Representative Lunsford's good character.
That shouldn't take long. House Bill 600 came at the request of some members of the prosecutorial community, and it basically grants in 2 or 3 areas that I'll let District Attorney Floyd expound upon the same rights as the defense has in criminal cases, and basically it's just designed to level the playing field. And with that, Mr. Chairman, if it meets with your approval, I'll let District Attorney Floyd sort of go through the bill in a little bit more detail, or as much detail as he cares to.
Thank you, Mr. Chairman. Tommy Floyd, the District Attorney from the Flint Circuit, Henry County. This bill cleans up some language in various code sections and significantly changes certain things. Section 1 simply removes the City Court of Atlanta, which is a defunct court. Section 2 clarifies the right of the state to appeal the grant of a motion for new trial or an extraordinary motion for new trial. And over in the bill, as it relates to motions for new trial, on line 105 and 106, it makes a motion for new trial or extraordinary motion for the purposes of this code section a final order, so that the state may directly appeal as opposed to a certificate of immediate review. In Section 3, lines 53 through 55, it changes some language but doesn't change the intent, except for the issue of where a court might compel the return of seized property. Now, that would be anything other than contraband that might have been seized subject to some kind of search and seizure action. There has been a case, McIntyre versus the state is the case, where that has happened. It's very rare, but when it does happen, that circumvents the motion to suppress issue itself. On the next page, where some substantive changes are requested, on line 62, it strikes it says from an order, decision, or judgment of a superior court. We struck or asked to strike of a superior court so as not to limit it to the superior court and make it available in all courts. Line 10 is a substantive change. Not line 10, section 10, line 68, allows the state to appeal from the granting over the state's objection a bench trial by a trial judge. This happened, the right was recognized in Zygon versus the state, I believe a case out of the Alapaha Circuit, and in Evans versus the state, the same thing happened in the Fulton County Superior Court, where the judge granted the defense's motion for a bench trial over the state's objection. The Fulton County District Attorney attempted to appeal the issue, and the Supreme Court said, because it's not one of those enumerated rights that the state has, it even indicated while that right exists, we can't. The issue is not properly before us, so we seek to insert that so that we can appeal such as that. Lines 70 through 72 create the right, if a court finds some rule, statute, or treaty unconstitutional, we can appeal that directly. Line 12, in an order by the court disqualifying a district attorney's office to appeal it, those would be new appellate rights. Line 80 through 86 allows the court to have the same right, the district attorney to have the same right that the defense would have in the event that the defense, for example, loses a motion to suppress. There are other pretrial issues on the table that say the defense won in or they were granted. It allows the state the right to cross appeal, which the defense has now. If they take something up and we have other pretrial issues, then we can take it all up at the same time. Section 4, line 97, makes it clear that the state has the right to direct appeal as opposed to having to seek a certificate of immediate review in cases where evidence is illegally seized and motions to suppress have been granted. Line 103 goes to the bench trial issue. That's where it says paragraph 10 or 11. The bench trial is 10, subsection 10, and subsection 11 is the where a statute is declared unconstitutional. This would give us the right to directly appeal those adverse rulings. On lines 105 and 106, it makes it clear that the granting of a motion for new trial or granting of an extraordinary motion for a new trial for the purposes of this code section only are final orders. Therefore, we may directly appeal those rulings. In section 6, it gives, section 6, lines 118 through 124, basically gives prosecutors in inferior courts, such as municipal courts, the right to appeal when certain statutes or city ordinances are declared unconstitutional. Line 126 provides that where the appellate chapter has been previously strictly construed, this would allow the appellate courts to liberally construe the code section, which is in line with the majority of the states in this country. Section 7 actually is clean-up language. It's repetitive to some other language, but it goes into 1518.5 and makes it compatible with this particular bill. Same thing with Section 8. Section 9 is just takes out the City Court of Atlanta. And that's as quickly as I can go through it and explain it.
Pretty good. All right. We have a question. Recognize Representative Knox.
I heard you cite a couple of cases in support of your changes. in, I think, section, let me see what section it was. Section 2?
Yes, sir.
Okay. And so what cases then did you cite in these other sections that you're asking for these changes? You have case law that you're asking for these changes to be made in response to case law in each case, that there's a change here?
Not necessarily that the appellate courts recommended the change, but that these issues were taken up in the appellate courts that illustrates the need for the change.
Okay. Well, I mean, is there a new law then that puts some sort of restraint or infirmity on the part of the prosecution that they're unable to address these issues without having a change in the code?
Yes.
Okay. Can you tell us what those are?
Yes. In the bench trial issue, for example, I cited Zigan and Evans. Zigan is 281 Georgia.
What section are you referring to again?
Excuse me. I'm on page 3, section 3, subsection A10. It's on line 68. Begins on line 68. Zigan sets out the right that the state has a right to a trial by jury. It clarifies that we have that right. Evans stands for the proposition that even though that was before the Supreme Court would not address the issue because it was not properly before the Supreme Court and could not be brought properly before the Supreme Court by the state because it was not one of the enumerated rights of appeal that the state had.
And those are enumerated in the code. The rights of appeal with respect to those issues that are enumerated that you can do a direct appeal on?
No, that's what this seeks to do.
Okay.
The right, for example, the bench trial, is not set out in the code anywhere that the state clearly sets out that the state has a right to object to a bench trial. But there are some case law, and the Zigan case basically solidifies all of that and says, yes, the state must agree before there is a bench trial, as well as the defense must agree. Evans, when that was done, after the Zigan case, another case came up in Fulton County where the judge basically ignored the law, ignored the Zigan ruling, and the state attempted to appeal that, and the Supreme Court would not hear it because it was not an enumerated right of appeal. So,
just from whoever's benefit, I guess, well, are you saying that either the defense or the state can ask for a bench trial, but that the judge is not authorized or will not be authorized under this change to grant a bench trial unless both the defense and the prosecutor agrees?
No, sir, that's not what I'm saying. It may be a little difficult to understand because most judges follow the law, but occasionally they don't. As in the Evans case, I mean, I'm not making it up. It's in that case. The right for the state to object to a motion for bench trial by the defense has been established by the Supreme Court of Georgia in Zigan. It's not in the code. This doesn't put it in the code. This simply gives us the right of appeal in the event that that right that's already been given us is denied us. In other words, the defense says, Judge, we want a bench trial in this death penalty case or whatever kind of case. And the state says, Your Honor, we object to that. Then the judge says, well, we're going to do a bench trial anyway. It's faster, it's quicker, and we're going to do it.
All right, let me stop there. So you're saying that you would deny it on the basis you would not want a judge to hear this without a jury because, well, why?
Well, I don't know that I would, but there might be.
But this would give you the right to do that.
This would give us the right.
But why would? Okay, so my same question is the same. If you want a right, you want it for a reason, and the reason would be so that you can exercise the authority that's given to you under it.
Exactly.
So that means that you want to be able to say, no, we're not going to agree to a jury trial. And I'm asking you, why can't you? Why would you not want to agree? Why would you not want to agree to a bench trial? Rather, I mean.
I normally would, quite frankly.
That's not my question. You know what I'm asking you.
No, I'm not sure I do.
Why would a prosecutor not want to agree to a bench trial in lieu of a jury trial?
He or she might think that the judge might not rule the way a jury would.
And
We already have that. We already have that right. We just can't enforce it. That's the point of this bill.
And so you're telling me that it's not in the law, that it's not in the case law that you can enforce it.
That's exactly right. It's in the case law that we can't. We cannot appeal that issue if the judge rules adversely to us on that issue. We can't bring that before the Supreme Court.
And you consider that a problem for you because why?
This came out of Fulton County, and I think someone from Fulton County is here to speak on it, where they did not want to do a bench trial for whatever reason. And they asserted their right not to be subjected to a bench trial. The judge overruled them, and they had no recourse.
The defense asserted their right?
The defense moved to try the case before the court without a jury.
Mm-hmm.
The defense, the state objected to that.
Mm-hmm.
The court did it anyway over the state's objection, where there was a clear right for the state to object. There simply is not a remedy for the state to appeal that adverse ruling.
Well, is there a reason why both the Supreme Court and the Georgia General Assembly up until this time has withheld that right from the prosecution? I mean, it would have been simple enough to put it in here a long time ago, wouldn't it?
I don't know that it's ever been raised. I'm not saying this is an everyday occurrence. This is a rare occurrence. And I think if you pass this bill, it will become even rarer.
Okay, so you're not sure whether we have the problem that we need to deal with?
No, I know we have the problem. I'm saying if the judges realize, a judge that might be inclined to do this, most wouldn't, frankly, but one that might be inclined to do it would not do it, knowing the state had a right to appeal that directly, that adverse ruling.
All right. Okay, tell me the other case law, if you don't mind, on the other changes that you've asked for.
The other case that I cited that illustrated the problem was it is relative to the appeals and denials or granting of a motion for new trial or extraordinary motion for new trial is Ware versus the state.
And where is it? What's that in relation to? What section is that in relation to that you're citing that case? Section 2 as well? Okay.
Well, not as well, but in Section 2. You want the site?
Yeah.
282 Georgia, 676.
Okay. Okay, and that's why we need Section B there, because of that case?
Not exactly, no, sir. Section B really clarifies what seems to be the law. It's a little unclear, but seems to be the law that the state has a right to appeal after seeking a certificate of immediate review, an adverse ruling in a motion for new trial or extraordinary motion for new trial. Section B clarifies that, sets up the standard of review, and if you move over to line 105 in Section 4, it gives us the right of direct appeal as opposed to the right to seek a certificate of immediate review.
All right. Where else do we have a case that supports the request for the changes you've suggested to Georgia law on this?
McIntyre.
What section is that referring to?
And that's in Section 3. It relates to
line 68.
No, sir. Line 53 through 55. It's 191 Appeals 565, and it is a case that simply illustrates a relatively minor problem of where a judge granted a defense motion to return certain seized property, not contraband, but I don't remember what it was, a TV, a gun, or something like that. That we could, if the court had granted the motion to suppress, we could appeal that as a final order. But the way it was done in this particular case, we were not able to appeal it, and that's what McIntyre stands for.
Okay.
I believe that's all I've cited.
All right. The rest of the changes, lines 68 through 75 and 80 through 86 and 91, 92, line 97, line 98 through 106, line 113 and 114, and line 118 through 124 and 126. None of those have any case law that you're citing to support the request for those changes in the Georgia Code?
That's correct.
All right. Okay. Well, just as a, if I may, Mr. Chairman, just as a,
Yes, sir.
as a, I heard you refer to the rights of the prosecutor, and I'm not familiar with the term the rights of the prosecutor. I thought the prosecutor had duties under the Constitution, not rights. That the defendant is the one who has the rights under the Constitution. Am I getting this confused?
I don't think so.
Okay.
I was not using rights in the term constitutional sense. The right in the sense of the ability to.
Okay. So then the changes that these are some pretty significant changes, and they seem to be quite a few of them that you're asking for in this particular section.
I would agree with that.
This has not been before a subcommittee, has it?
No.
Did y'all request that it not be heard in a subcommittee?
No.
When was this introduced?
I don't know.
You don't know? Okay.
Mr. Floyd, do you know what it feels like to be cross-examined now?
Oh, I've been crossing several times.
Mr. Chairman, at appropriate time, I have a motion.
Okay. We've got a question from Representative Abel.
Actually, I think I will defer to, I think Chairman Knox is going to make the motion that I would like to make.
Okay, she waves. Mr. Floyd, let me just to clarify on the issue of bench trial versus jury trial. There is not a provision for interlocutory review presently under the statute for a denial of a jury trial to the state.
No.
Okay.
Nothing at all.
Is that something that if another issue went up on an interlocutory basis, that the state would be able to raise that as an enumeration of error?
No, sir. We don't have the right to cross appeal. This would give us the right to cross appeal.
Okay. So it's basically, at this point, it's a right without a remedy.
Exactly. It's exactly what it is. And this bill, from an overall standpoint, we had a bill last year that just dealt with the bench trial issue. We have sought in this bill to simply stop piecemealing the appellate ability of the state. I won't use the word right because Chairman Knox is correct about that. To quit piecemealing that, put it all in one bill and bring it to you. And that's what we've attempted to do.
Okay, thank you, Mr. Floyd. Do any other members have questions for the author or for Mr. Floyd? Seeing none. We have signed up, and I will recognize Sandy Michaels with Georgia Association of Criminal Defense Lawyers.
Yes, very briefly. First of all, because the bill...
Can we get you to...
For the Georgia Association of Criminal Defense Lawyers?
If you will come and have a seat, and
I don't have that long to say, but thank you.
I just want to make sure we get you on the mic.
Thank you so much. One of my concerns is because the bill is so extensive and makes huge, wide-sweeping changes, and we didn't have a chance to hear it in subcommittee. This is the first time it's come before it. We have a number of experts in our association, DUI experts, appellate experts, and because some of these hit different areas of expertise, we respectfully ask the committee to put it in a subcommittee so at least some of the other parties can be heard. Some of the parts of the bill we don't have problems with. Some of them we do, and some of them need expert advice and testimony. Again, I would just respectfully ask that the bill just be put in subcommittee so both sides could be effectively heard as opposed to just today.
Thank you.
Thank
Any
you.
questions for Ms. Michaels? Representative Levitas?
This bill was second read on the 4th. What have y'all done since the bill was introduced as far as gathering your experts and all that?
Well, as you know, Mr. Samuel is the person that does most of our appellate work. He's been in Boston since last week, so he's not been able to do that. And then, of course, Jack, our other expert, has been in Detroit since last week. And so those are the people that we usually vet the bills before. In a bill of this nature, we try to send out an issue to the DUI attorney so they can take a look at it too.
Have y'all done that?
Them. No, I've not sent this bill out on the internet. Okay. Just to Don and Jack, whom I should know you all know.
Okay, thank you.
Okay, is there anyone else that would wish to speak? Yes, ma'am. If you will come forward and give us your name.
Hi, I'm Betty Ann Hart, Deputy District Attorney for the Fulton County District Attorney's Office, in charge of the Appellate Division. There were a couple of questions, and I guess since we've making the law in this area, I'd like to respond to them.
Okay.
Especially with regard to Representative Knox's question about whether or not we were changing anything. Specifically, both the Supreme Court and the Appeals Court have said that if it's not in writing, if the legislature has not specifically set it out in Code Section 571, then we do not have a right to appeal anything. We are limited to only those things that are specifically in that code section. The legislature, in its wisdom in 2005, did give us the right to appeal a grant of a motion for new trial. However, when we attempted to appeal that grant, that motion for new trial, Justice Carley said specifically that it was not stated in the legislation, and therefore, just as clearly as the legislature refrains from adding any new exception whatsoever, then you have to have a certificate of immediate review. So we are very strictly construed with regard to this particular section. So that's like giving us a right without a remedy. If a judge, to the question of why would you want to appeal it, most questions would not be appealed because there is something in the law, such as venue or charges or what have you, that's clearly not in the purview. But when you are talking about discretionary things like ineffective assistance of counsel, I will just say that between the period before the Supreme Court said that we had the certificate and the time that the legislature granted that right, after that decision, our numbers of new trials doubled. And that is an expense to the state. It is very detrimental to the victim, who has to be brought in for several trials. Last week we had our third trial for our murder suspect. He was convicted for the third time. I'm bracing for the grant of a motion for new trial. That meant victims had to come in 3 times. The first time the judge granted on ineffective assistance of counsel. Second time there was no reason granted. Third time. So this person has actually been convicted 3 times. The state has gone through 3 trials and there's been no oversight. As to the bench trial, you may remember that was a death penalty trial in which in Fulton County, a judge actually found a defendant guilty and sentenced him to death, at which time he appealed and said that she had promised him something, and that had been given over the state's objection, the bench trial. So that resulted in a second death penalty trial. So we're talking about enforcing the right. The courts may very well agree with the decision, and that's the way things go. But it's to curtail abuse and to allow some oversight to the question. As to the right of appeal, I can tell you that when the research was done for the 2005 Act, we found that Georgia was in the minority of jurisdictions with regard to the state's right to appeal. So that's where we are.
Okay. Got some questions, Representative Levitas.
This is for the author, so if you want me to ask it now, I can ask it now. If not, I can wait until the appropriate time.
Let's finish up with this
Okay.
witness. Representative Byrd? I'm sorry, Knox.
With regard to those cases that you've mentioned where there were convictions, what do you mean by a conviction?
I meant the jury in the motion for new trial. We had 3 different juries who found the defendant guilty. And the judge reversed on 2. On 1, ineffective assistance of counsel, and on the second, no reason was given.
Okay. Those are all within the purview of the judge, though, aren't they?
Not since 2005, when the legislature gave us the right to appeal motions for new trial. What the Supreme Court has said that it has to be, we have to get a certificate of review. Generally, if a judge has no problem with the decision, their certificate of review is no problem. But what falls within the cracks are these discretionary type things that may cause some concern.
Well, if the judge, and I don't mean to argue, but if a judge says that there was ineffective assistance of counsel, even if the jury found some way, that's in accordance with the law and the Constitution both, isn't it?
Well, with,
I mean, there's
with
nothing
regard to
wrong about the judge doing that, is there?
With regard to the Constitution, there's a specific standard, Strickland v. Washington, and there are some issues when the Supreme Court and the Court of Appeals has said that certain matters are matters of trial strategy, and the judge does not follow that law. That is a plain error type of thing that could easily be reviewed. So that it's not just by the same token, the Supreme Court may say, yes, the judge is correct, but we do follow the law.
But in this case, you get to prosecute, basically you're getting to prosecute the case twice then. No matter what happens, y'all get another bite out of the apple. That's where we're headed, aren't we?
That's what happens with the grant of a motion for new trial. And I'm saying from the standpoint of judicial, it's not that we don't get an opportunity to retry the case. We do. And in most instances, we are successful. Again, as with this last murder trial that I was telling you about.
But essentially, aren't we moving to a situation where you get to retry the case if you don't like the outcome, whereas the other way around it used to be, I think, that if you were found not guilty, you were finished. Y'all were trying to get back into where you can get the case retried if you don't like the outcome or the judge says or whatever, aren't we?
No, this does not pertain to verdicts of not guilty. This only pertains to a not guilty verdict is not something that we can appeal. No. Well,
I understand that, but I'm talking about in practical effect. The more opportunities you have to appeal any kind of decision the judge makes, the more opportunities you have effectively to overcome the verdict of the jury or of the judge if it's a bench trial, either one. Because the more ammunition you get to pile up on your side, the more chances you get to convict the person that's accused. Correct?
Actually, no. Because we do get a chance now, and I'm just addressing the issue of motion for new trial, we do get a chance to retry the defendant. The only, as I said, the only advantage to the state would be the possibility that we could avoid having to bring in more victims and witnesses and redoing the trial.
Okay, well, let me ask you about that. What aside from we have some code on the victim, and I know that's politically correct now that the entire judicial system revolves around the victim now instead of around the Constitution and protections for the accused from the state and from the misdeeds of the state. That's what the whole Constitution's about. Wouldn't you agree? It's to protect everybody from the government, from you and from me, correct? And particularly when you're on trial for your life or for some other offense.
Well, the concept of a fair trial means that both the state and the defendant have to observe the due processes that are given by the Constitution. That's correct.
Okay. And don't you think, and I know you're only addressing one part of this bill, but I'm sure you read the whole bill, wouldn't you think that would you agree that there's some significant changes and erosions in the balance of the rights given to defendants as opposed to the rights that the district attorney may have?
Well, Representative Knox, if I were a defense attorney, I may answer you a little differently from being the prosecutorial standpoint. We are here really, it's a balancing act. And to the extent that everybody follows case precedent and prosecutors exercise discretion and the rules of law are followed, we don't have these issues. An appellate process, and that's what we deal with now, gives the Supreme Court and the Court of Appeals an oversight, an ability to look at what happened below and say, okay, everything was fine. This was okay. Right now, what this bill does in terms of the rules of court is to say that the state has an equal right to have that appellate court look at what was done.
We've heard a lot of over the last number of years. We've been hearing that people are complaining that it's taking too long to get justice and the victims are suffering too long. I'm trying to understand how giving yet another of reasons to appeal a case is going to help that process along.
Well, in the case where I told you the conviction was overturned 3 times, when 36 people have made a decision, that gives you some idea of the quality of this case, which is a murder case. And you know from trial experience that The prosecutor's responsibility is to prove the case beyond a reasonable doubt. That means the prosecutor has to bring in everybody, law enforcement officers, witnesses, and what have you, from wherever they may be. In Fulton County and other counties across the state now, we're mobile. It may be from Nevada, wherever. In our courts, it takes about 6 to 7 months for a case to get to a motion for new trial status. The participants in that trial have attempted to go on with their life. To grant a motion for new trial and to get it back on the calendar and to get all those people together again is not a whole lot more time than is required for the courts to review it, which would be about a year.
And one final, Mr. Chairman, if I may. I mean, really, this is not really about it's supposed to be easy for the prosecution or the government to try a case, is it? Isn't the real issue here whether or not, and not even, the real issue is not even whether the person's guilty or not. The issue is whether you can prove the charges that you made against that person.
That's correct. And when we've proved it once and there is a questionable ruling because it's not a clear ruling, there's not case precedent to support it, or there's not a law to support it, then the state needs the ability to have that reviewed by an appellate court, we feel.
Okay, thank you. We'll recognize Representative Abrams.
Thank you. Just two questions. Having, on the case that you mentioned with the 3 convictions being overturned, typically convictions are overturned because of errors that the appellate court finds. Can you speak to the grounds for which the appeals were, or the convictions were overturned?
Yes, that's the specific issue we are addressing here. At this particular point in time, a motion for new trial can be granted without any reason supporting it. There's
so the judge made
no findings of fact,
okay,
or what have you. The other time it was reversed, it was because of an ineffective assistance of counsel issue, which probably we would not have quibbled with. Okay, but to bring the defendants back in a third time, and we may still be facing a grant of a motion for new trial, it tends to get into questions of beliefs and concerns as opposed to law. And we're just asking that where there are issues of law involved, that we be allowed to have it reviewed.
If I may follow up, I'm certainly sympathetic.
Let me emphasize that in 2005, the legislature gave us that right to have those decisions reviewed. In 2007, with the Ware case out of DeKalb County, the court said that yes, we had the right, but we had to get a certificate of review. Generally, we'll have no problem doing that. But where there's a genuine issue, we have had several cases in which the judge has refused to give us that certificate.
Thank you. My second question is one of timing. Given the importance of this bill and given the number of case citations made, is there any urgency other than, I mean, certainly the understandable desire to have some remedy granted now, is there any urgency to passage of this bill today that you can articulate for us?
I'm aware that there is a subcommittee process in place on this committee, and several of the issues have been vetted years before. To the extent that there may be new issues that you're pretty much aware of, have become aware of, that may be a good process.
Thank you.
Thank you. Representative Mangum.
Thank you, Mr. Chairman. I believe that Representative Abrams has pretty much asked my question. One other question, I'll go ahead and ask that because it is always an honor to have the former representative before us, as well as the Fulton County DA to come in here. It's very heavyweight. We want to look at this very clearly. But how prevalent is this problem? Is this something that's, I think you said you had several cases that are, how prevalent is this issue, one?
We're addressing several different issues, okay? The motion for new trial.
The new trial issue in particular.
It becomes more prevalent the further out we get out from the 2005. And that is to the extent that people become aware that we have no remedy if it's done. What we have seen is an increase, as I said, a doubling between those two periods of time.
It is for the purposes of delay. Is that what the motions are seeming to?
Pressure, actually, I think, to try to get a different result.
I will pass.
Okay, thank you. Any other questions from the committee?
I would just like to say that while a subcommittee process, and yes, I have been involved in that, may be appropriate if you think the bill is complex, these are very urgent issues that prosecutors face every day with each trial. As we speak, Friday, had an issue with regard to the grant of a bench trial. So it's something we come up with every day. And disqualification, of course, those are issues that vary around the state. But we hope it won't delay beyond this legislative session.
Okay, thank you. Does anyone else wish to speak on the bill? All right, I know Representative Levitas, you had another question for the author, I believe.
Chairman Ralston, has anybody approached you from the defense side, from GACTL or any other group, since this bill's been introduced and asked you to engage in a discussion with them about it?
Not about this bill specifically.
That's what I mean.
We've talked about other bills.
No, I mean this bill specifically.
No. All right. Chairman Ralston, do you have any feeling about the question has been raised about a referral of this bill to subcommittee? Do you have any position on that at this time?
I'm sorry now?
The question's been raised by some of the committee members about referral of the bill to subcommittee. What is your position on that?
Well, one of the other presenters earlier referred to the fact that this bill was actually before this committee last year, not exactly in this format, so it's not a new subject matter to this committee, number one. Number two, for whatever reason, I mean, we're here, either we hear the bill and this committee acts on it today, or for all practical purposes, we wait a year, I mean, with where we are in the scheduling process. So that would, that's kind of my thought process on it.
Okay. Representative Knox.
I'd like to be recognized for a motion, Mr. Chairman.
I think now would be the appropriate time.
Mr. Chairman, I'm going to move to table this bill. I'd like to have the committee consider doing that for the purpose of having the bill reviewed in subcommittee. I think there are some very significant changes in this bill to the criminal code, to the rights of the district attorney, as it's been termed, and the rights of the defense in the criminal law area. And I think we ought not be rush into anything. The only thing that we've had some cites, but those are only for the first 2 pages of the bill. The rest of what I consider to be the major changes to the bill we're being told there's no case law compelling that. It's simply a matter that the prosecutors think it would make it easier, I guess, for them to prosecute their cases. And I'm not satisfied that we should just go ahead and proceed simply on a request without some authority or some discussion to give us some confidence that we ought to be making those kind of changes. So I make that motion that we table the bill.
We have a motion to say, is it your intention, Representative Knox, that the bill be tabled or referred to subcommittee?
Well, I'd be satisfied with it being referred to subcommittee. I'm not sure that would be they would have a different outcome at this point, as the chairman suggested. So,
well, I'll leave it to the gentleman to decide whether or not you want to change your motion to a motion to refer it to subcommittee, or what we have on the floor right now is a motion to table with a second.
I think I'll stick with my motion to
Okay.
table. No, you know what? I'm going to move to refer to subcommittee. Thank you.
Okay, we have a motion and a second. Just one moment. Representative Abrams.
Just to speak to the existing motion on the floor, with all due respect to Chairman Ralston, I do remember this bill from last year. My concern is that this is a fairly complicated area of law, and the changes that were made in this version are fairly substantive changes. And I think the duty of this body, and particularly this committee, is to fairly hear all of the implications of these changes. And while I do grant that this is not the first time we've seen it, it is the first time we've seen it in this form, and it is certainly the first time we've seen it without having, I think, what I consider one of the hallmarks of this committee, which is having adequate testimony to help us illuminate all of the concerns and all the impacts of this bill. And I think that while, with all due respect to the speaker, who pointed out that there is a sense of urgency that prosecutors would like to see this done differently, this is an area of law that has existed for some time, and she provided no information that said that passage this year would that there's any necessity to passing it this year. And therefore, I think referring this to subcommittee would do not only the prosecution and the defense bar, but do this body, I think, great good, so that we could fully understand this bill. And so would support Chairman Knox's recommendation.
Okay, thank you. Representative Levitas.
I'd like to be recognized for a substitute motion.
Go ahead.
Motion to table.
Motion to table.
Motion to table.
We have a motion to table on the floor.
It was changed to a motion to refer to subcommittee, and I'm asking for a substitute motion.
I'm sorry.
To table.
I'm sorry. That's correct. That's a substitute motion. Is there a second?
Yes, there is.
Well, let me just see if is there a second. All right, we'll go to Representative Setzler.
Does the chairman have any sense of inability, given the schedule, given bills passing out of committee into the Rules Committee? I think the Rules Chairman has set Wednesday afternoon at 2 o'clock for the date to ask for bills. So conceivably, if this were passed by this committee tomorrow by 5 p.m., it could be referred to Rules and be put on the consideration calendar for Wednesday. I mean, is it not true, Mr. Chairman? And I'm understanding Representative Levitas' motion as a means of keeping this proposition in full committee, is it not true, so that we can consider it potentially tomorrow and move it forward to Chairman Ralston's end, but to address some concerns there might be. Is that not true, Mr. Chairman?
I feel certain that's probably Representative Levitas' point, but you're right. In my understanding, the Rules Chairman is set Wednesday afternoon as.
And Mr. Chairman, could I
the last hearing?
Could I guess without continuing a parliamentary inquiry, be recognized to ask a question to the author of the bill?
Sure. Go ahead.
To Chairman Ralston, kind of outlining the scenario I just kind of highlighted, would that be workable in your mind, or would you prefer to take a swing at it today and see how it plays out?
I'm not sure I know the schedule of the full committee. Full committee meeting tomorrow. No. Obviously, my hope would be that that we would look at this bill on its merits and move forward. I think it's a good bill. I don't think there's anything terribly complicated about it. Most of it's been here before, and So, I mean, I think there are motions that you can make if you just don't like the bill, obviously, that kill it for a year, and so I would prefer, obviously, not to see that happen.
We'll go to Representative Bearden.
Parliamentary inquiry, Mr. Chairman.
Okay.
I was just going to bring it to attention. Is it not true that if you want to see this bill pass, what you need to do is vote against the motion to table if it gets second, then vote against the next motion. Thank you. I'm getting confused with the tubs and the motions here, and then vote on the bill just up or down.
That would be appropriate, I think. Okay. And Representative Mangum, you waive. Okay. Is there a second? We have a motion on the table from Representative Levitas to table the bill. Is there a second to that motion? Second. Okay, we have a motion and a second. I believe the motion to table will take precedence. And so, is there any further discussion on the motion to table from committee members? Okay, hearing none, then Representative Setzler.
Mr. Chairman, I guess in the spirit of parliamentary inquiry, what I don't want to do is I don't want to take something that should play out perhaps over 5 minutes and make it play out over 30 seconds and make a mistake as a committee. And I know we've got a substantive bill behind this one. I would just request to the chairman that we perhaps could we deliberate as a committee procedurally how we might want to move. I just know that when you make 5-minute decisions in 30 seconds, bad things happen. And I'd like to move this bill forward. I think the bill stands on its merits, but if there are some specific concerns that could be addressed that perhaps members of the committee had, perhaps the committee could address them over the next 5 or 10 minutes, and then we could move forward.
I'd like to give Representative Ralston a vote on the bill, but I think that the gentleman has a right to make a motion to table, and I think if you've got a discussion on that issue, now is the appropriate time to.
And I just asked that
forward.
question, I guess, Mr. Chairman, in the spirit of a parliamentary inquiry. I believe it to be Representative Levitas's intent to offer a motion to table as an roundabout friendly motion, and I'd like to maybe deliberate as a committee as to where we're headed.
Okay. Representative Ramsey.
Yeah, that's me. If we were to table it and keep it in full committee, would you be willing to get with the various parties and work with them over the next few hours and tomorrow morning if we were able to get another meeting scheduled, Mr. Chairman? Do you think that's feasible? Is it?
I will do whatever it takes to move this bill forward because I think the people of Georgia would benefit from this bill.
Yes, sir. Thank you.
Okay. Representative Mangum.
You have some great questions. That was my question. Can you go work it out?
You just can't get one in, can you? Okay. Representative Levitas. Waive. And Representative Setzler.
Is it the opinion of the author that the objections that are raised by some of the questioners can be resolved, or have they already been reduced to their core public policy questions that even if we took 24 hours, 48 hours, we're still back to the language that we have today, and it's an irreducible issue? Because I don't want to waste time if we've already really gotten to the crux of it.
Am I under oath? The answer is yes. I think we can resolve some of the issues. To be fair with the representative, I'm not sure. Some of these issues I think are just policy differences. I mean, it really is where you come down on these issues, and they're honest differences. And so I'm not sure. I think we could get to a point beyond which we might not make any further progress.
Okay. All right. Seeing no further inquiries, we'll go ahead and call the question. Representative Levitas's motion to table. All those in favor of tabling House Bill 600 will signify by saying aye. All those opposed? No. Okay, well, we'll call for a showing of the hands. All those in favor, please raise your right hand. All those in favor of the motion to table, raise your right hand. All those opposed? Okay. It appears that that motion is defeated. Now we'll go on to Representative Abrams.
Yes, just to add to my earlier statement about the Knox motion, my intent is not to, I actually do not have strong opposition to some portions of I think there are some good pieces to this bill. So contrary to the question suggesting that there may be just a policy opposition, I truly seek illumination on the issues, and that cannot be provided given the speakers we have today. And so I'm simply requesting adequate time to fully adjudicate the bill, and so don't want anyone to think that I'm standing on either opposition or in favor of the bill. It really is I really am seeking additional information, and I think that is true with Chairman Knox.
Thank you. Representative Bearden.
Just to touch back from earlier, if we want to vote this bill on its merits, we need to defeat this next motion. Is that not correct?
That would be correct.
Thank you.
As I understand it. Okay. We'll now act on the Knox motion to refer HB 600 to subcommittee, and I'll call the previous question. All those in favor of the motion to refer this bill, House Bill 600, to subcommittee, signify by saying aye. Aye. All those opposed, no. No. Okay, we'll ask for a showing of the hands. All those in favor of the motion to refer to subcommittee, please raise your right hand. All those opposed? The chair will vote no. Now we'll move on to the previous question, House Bill 600. Any further comments, questions? We have a motion do pass. Is there a second? Okay, we have a motion and a second do pass. Any further discussion? Hearing none, all those in favor of passage of HB 600 signify by saying aye. Aye. All those opposed, no. No. We'll ask for showing in the hands again. All those in favor of passage of the bill, raise your right hand. Six. All those opposed? Chair votes aye. Bill passes. Motion to reconsider? Well, I think you can make a motion to reconsider, but I believe the time to reconsider would be now.
Well, I didn't understand that to be the case. From previous hearings, it was, and I don't want to belabor it, but if that is what the rule is, we'll have that rule forever, so they won't change the rule, because I know that we have done this with, on a different day. That's why I think it's important, not because I am one way or the other on this, but I am concerned, parliamentary-wise, that if that's the way the rules are going to be, and I know that you're not the chair ordinarily.
I'm not.
But I am concerned because I've been on a couple of committees where something I thought was voted one way and we vote on it again the next day or the next week. And I just want to be clear that the rules are one way and the rules don't change depending upon the whim or wishes of the finger in the proverbial wind. See which way the wind is blowing.
Well, I appreciate that. My understanding, I'm looking at the committee rules, and the committee rules do not, from what I can see, do not address the question of reconsideration, other than that the rules of the House shall control in any case not provided for in these rules.
Well, it is my understanding in the House that you give notice and you vote the next occasion.
That's my understanding, unless you're within the last 3 days. Does Legislative Council have anything to offer or add on that?
Good answer. Good answer.
Representative Setzler.
If parliamentary inquiry, is it not true that if the the motion to reconsider fails, a similar motion to immediately commit to the Rules Committee or advance to the Rules Committee would be in order, similar to that which is done on the floor of the House?
I've never heard of that in a committee.
I don't know if that exists.
Right. It goes to the general calendar.
I guess I don't know that a second motion to reconsider would be in order if the first one fails. So it happens next. Okay.
Well, unless anyone has anything, Representative Ralston, you have anything to add on that?
This has just been a great experience being back today, Mr. Chairman, and you know, I've really missed this committee, and now I know why.
Very enjoyable chairing it. Well, based on the rules as written, I think that we will have to defer the motion to reconsider until the next convening of this committee. And so we will, while House Bill 600 has received a due pass recommendation, it is subject to that motion to reconsider. Yes, sir. Go right ahead.
Is it not correct that the parties that are involved in this matter may get together and resolve their differences prior to our getting together?
Sure.
Thank you.
Would be desirable, I think.
Thank you.
And Representative Levitas.
Move to appeal the chair's ruling.
How about that?
They can't touch me.
All right. All right. We have a motion to or appeal of the ruling of the chair. Representative Setzler.
I'm not sure I want my name mentioned in the same sentence as that motion, but my question for the chair is there a mechanism that the committee can use to vote immediately on the motion to reconsider? I mean, is it not within the discretion of the chair, given crossover and given the reasons the committee wanted to act immediately on it, consistent with our rule of last day, for example, the last day before crossover? Correction, on crossover day and on day 40, I believe it's the policy of the speaker on the floor that motions to reconsider are taken up immediately. Are we not, in essence, in that posture now, and could that not be the ruling with respect to this motion?
Well, I think we're close to that posture, but I think the problem that we have is that we're not actually within that window of time, and I would think that unless we had a unanimous agreement to suspend the rules and proceed on to a vote on that at this time, that we're probably bound by the rules.
Well, Mr. Chairman, the reason I make that, I would make that case is, isn't it true that we do not have a scheduled committee meeting between now and when Rules is going to finally convene on Wednesday at 2 p.m.?
We don't.
We could conceivably schedule one, but there is no currently scheduled meeting. So,
correct.
This being the last scheduled meeting, it could be easily argued that we're in a posture of this being the last committee meeting before that final consideration, that we would be exactly there.
That's true. That may very well be, but I think we may very well be in uncharted waters. So, Representative Abrams.
With all due respect to Mr. Setzler, I think that that's a construction of the rules that is not, there's no plain reading that can make that construction. It is within the ability of this committee to convene itself. We set our own schedule, therefore we can convene ourselves at will to meet the parameters that are required, and therefore I think that shouldn't hold.
Thank you. Representative Mangum. Nothing further?
She said what I wanted to say, because we can have a meeting. Thank you. Bye.
Representative Levitas.
Thank you.
Is it the chair's intention to convene a meeting either later this afternoon or tomorrow morning?
Well, I think the rules require that the notice be given for consideration on the next legislative day.
And is it the chair's intention to have a meeting? I know that our chairman is feeling under the weather, but is it your acting as chairman? Is it your intention to have?
Yes, I would convene a meeting tomorrow.
All right, yeah, I withdraw my motion to appeal the chair's ruling.
All right. Representative Bearden.
Pass.
Okay. All right. Well, we have a motion or a notice of reconsideration for tomorrow. We will schedule a meeting and give everyone notice of that, and we will. You do have a question, Representative Bearden?
Since the schedule is already set for day 29, I believe Representative Levet's comment of 8 a.m. so this can get to the rules calendar, be set for day 30 on crossover day. I think that's the only fair thing to do for the author.
Well, we have another obligation at 8 o'clock a.m.
It depends where your obligation lies.
With a special guest.
Well, let's. Can we set it for 9 a.m. in the morning? Let's try 9 a.m. tomorrow morning. Representative Ralston, will that be sufficient?
I'm at your
Rules meets at 9.
hall.
Rules committee meets at 9. Yes, 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 it does.
Yeah.
Earl announced it does.
But it's meeting on rules committee bills.
Yes,
Mhm.
and there's at least one of us who has one there.
Well, we'll move forward with this one at 9 o'clock in the morning then. Okay. Thank you,
Thank you very
Representative
much,
Ralston.
Mr. Chairman, members of the committee. I can't wait to learn more.
Okay. We have one bill remaining, House Bill 177. Representative Williams. No, he's still here.
Well, we're on such a roll. It's gonna be. That's up to y'all. I'm ready. Where's Mike?
All right. We'll ask everyone to come to order.
Okay.
We got a quorum. Okay, we'll recognize. Let's see. At this time, we've had a number of hours of testimony on House Bill 177. I believe we've got some amendments that were going to be offered. Is Representative Knox?
Thank
here?
you, Mr. Chairman. I just.
Yes. Representative Williams?
I think that's a great idea. We've had between 6 and 7 hours of deliberation and sub. I did want to thank Representative Ramsey for allowing me to celebrate my little daughter's birthday Friday and presenting the bill. But at this point, I would really like to see the bill move.
And it is our intention to give the gentleman a vote on the bill today. Representative Bearden.
At the proper time, I'd like to make a motion to pass.
I think now would be the appropriate time.
Motion to pass.
All right. We have a motion to pass and a second from Representative Ramsey. Are there any amendments to be offered? Recognize Representative Knox.
Thank you, Mr. Chairman. I'd like to offer for the committee's consideration a substitute to HB 177, and the LC number is LC 370884S.
We don't. Those are being distributed now. No.
You don't have it? I think they were in the. They've been in the folder once before. 370884S.
We don't seem to have that. We've got 0887S.
This was in the. I know this was in folders either last meeting or meeting before last or something.
Yeah, this was a couple of times ago.
Yeah.
The last time this was introduced.
It got jettisoned.
Yeah. Is there a reason why we can't get? This is the one that was the Ramsey.
This is the Knox amendment.
There's another substitute. I think that Somebody offered. 0887S. I think that's Representative Ramsey's bill. Yes? Substitute?
Yeah.
That's Representative Williams' substitute.
Okay.
0887S is the one we're working off now. Which is a good bill.
Do we
Simple, too, isn't it?
Very simple.
There you go.
do we have that
Good and simple. You can't beat it.
Diane, do we have that available?
Yeah,
His amendment?
Maybe I could do it. Maybe I could do it. I'm not sure. I better not say that yet. The changes aren't drastic, but it would take us some writing on it to get the amendment. You want me to tell you?
Could we give you? You think you could get it together if we took a brief recess?
Yeah, that'd be fine.
5 minutes. Okay, let's take a 5-minute recess.
Hello.
Come back. All right, we're gonna call the committee back to order, and at this point we have a motion due pass on HB 177. That's LC 370887S. As I understand it, a motion and a second. That was a motion due pass by substitute, right? Correct. Okay. Now, it would be appropriate at this time, if anyone has any amendments to offer, then I will recognize you for that purpose.
Mr. Chairman, I'd like to be recognized for an amendment.
All right, Representative Knox.
Mr. Chairman, I'd like to ask, I got legislative counsel to craft the amendment for me, and she can, I think the everybody has 887S in their folder, and we're going to talk about the amendments to that, correct? Okay. Are you ready?
Looking at page 2 of 887 and page 2 of 884. You have those bills in your hand. And looking on 887 at line 59, you take out lines 59 to 62 and replace them with lines 56 through 64 of 884 and change the $100 to a number that is
25.
25. That's change number 1. Do you want me to do them one at a time, Mr. Chairman?
Yes, please.
That's
We-
one.
That's the first one.
That's the first one.
Okay. All right. Does everyone understand that? We'll go ahead and take that one up first. Does everyone understand that amendment that's been offered? We want to restate it. Legislative Council.
Looking at 887, take out lines 59 through 62 and replace it with looking at 884, lines 56 through 64, and in the two locations, lines 57 and 58, where it says $100, change that to $25.
Okay. Representative Knox, is that, now you're making that in the form of a motion?
I am.
Okay, is there a second to that proposed amendment? We have a motion by Representative Knox, second by Representative Abrams, for the amendment to Section 3. Is there any discussion on that motion? I'll recognize Representative Ramsey.
I waive, Mr. Chairman.
He waives. Any further discussion or any discussion on the proposed amendment? All right. Seeing none, we'll call the question. All those in favor of the first Knox amendment signify by saying aye.
Aye.
All those opposed, no. Knox Amendment 1 passes.
The second Knox amendment is on page 3 of 87, line 73, taking out 10 years and restoring the 5 years.
I'm sorry.
That's okay. On
copy of that 0884S?
There you go.
I'm not working at it. No, I'm not working from it.
Okay, the second Knox amendment.
Knox is looking at 0887.
Ms. Travis, you want to pull the mic?
Looking at 0887, line 73, changing, it says 10 years, taking the 10 years out and restoring the 5 years.
Okay.
So the penalty would stay the same.
All right. Does everyone understand the motion? Is that a motion, Representative Knox? Is there a second from Representative Abrams? Any discussion on that motion? All right. Hearing none. All those in favor of the second Knox amendment signify by saying aye. Aye. All those opposed, no. All right. That amendment carries. Any further amendments? Representative Lunsford.
Thank you, Mr. Chairman. On page 2, line 59, I apologize for coming in late. After the word copper, I'd like to see if the author has a problem with us putting a comma in there and then also include the word catalytic converters.
Now, is this on 0887S?
Yes, sir. I assume that's the underlying bill still.
And this is line, which line?
Well, it would be line 59 on 0887S, and it would actually be line 56 on 0884S.
Okay. And restate the amendment, please.
Well, what I'd like to say is on line 56, after the word copper, put in a comma, and then say catalytic converter. What I'm trying to do is, and if Legislative Council can figure out a better way of doing that, what I want to make sure is that we're covering catalytic converters to the same. It appears that we have a serious problem in our state with people recycling catalytic converters that weren't bad to begin with, that look like they've been sawed off with a hacksaw off of a new car at the car lot, and then taking them to a recycler's place of origin. And so I was thinking if we put the catalytic converters into the same provisions as copper, then we would still have the same rest of the provisions following it. Am I reading that right, Jill?
Do you want to define within the definition of copper property to include a catalytic converter?
Well, I was trying to include into the definition of what is being, basically we've singled out copper here to have special stipulations.
Right.
And I'd like to include a catalytic converter into those same special stipulations to let them apply to that as well.
We need to put catalytic converter everywhere where copper is, then, in order to do that.
I think, Representative Lunsford, the only place that we've distinguished copper from the others is in the amount of check writing.
Correct.
So I think you're in the right place.
Well, it's also...
So when we say a secondary metal recycler shall pay cash for any copper, comma, or catalytic converter property, but only if the amount of consideration is $100 or less, and then we've amended that now, I guess, to $25 or less. So I'm looking for ideas on this. I'm sorry I was out in the hall. It wasn't.
And then the next line is payment for any copper property exceeding the value of $25 shall be issued by check. It doesn't go there, is what you're saying?
You must be, are you looking at 0884S?
Yes.
Okay.
Because that's now what's on the table.
Okay, perfect. Thank you. I'll defer to Ms. Abrams. She's got a great idea.
Property on line 62.
Representative Abrams?
It would strike me that if we're looking at 887S,
We're not on it. The amendment passed, so the language is 884.
no, I understand the language is 884, but in terms of lines, which bill do you want to look at? Because I guess my only point would be copper property is now a defined term in the bill,
right.
And therefore, but since your point is only to require, it struck me that all you're trying to do is to require that under this section of the code that catalytic conversion purchases are also subject to the purchase by check, that you're not trying to change the underlying bill, you're simply trying to add yourself to that provision. And it would strike me that you would then add or catalytic converters after the word purchases between purchases and the period, because you're only trying to be inserted into that section. You're not trying to change the definition of what constitutes a copper property.
But you have to look at the bill 884, because that's what, you all passed that amendment.
Right.
Well, we're working from 887S, but 884, that particular language is being moved into 887.
So to your point, you're saying that we need to add it, copper property, secondary, I understand what you're saying. So it would have to be inserted after, for any copper property or catalytic converter, here, and then you'd again on that next line, any copper property or catalytic converter.
Right.
Okay.
And then, this is a question, then again.
At
on
the end.
Line 62.
Right. Although, why would anyone have a catalytic converter for a nonprofit?
Ms. Travis, is catalytic converter a defined term in the code?
I don't have any idea what a catalytic converter is at all.
Well, Mr. Chairman, if I could.
Yes, sir.
You can say catalytic converter. I mean, if you want to get technical, you could talk about palladium or rhodium or palladium or rhodidium, whatever, but it would just be much simpler to say catalytic converter because they use many different metals to react, and they're based on where it came from and what you're trying to pull out pollution-wise.
Well, I think that probably if we haven't defined it, it's going to have its usual customary meaning.
Right.
So we can go with it that way. Do you, Representative Lunsford? Do you want to state then
Yes,
the
sir.
proposed amendment?
If I could, Mr. Chairman, on line 56.
This is on 884.
On 884S, and that's
Okay.
where I was reading off the wrong version originally. After the word copper property, put in the word or catalytic converter, and then on line 58, after the word property, again put or catalytic converter.
Okay.
And then on page 3, line 62, after the word property, or catalytic converter.
Okay.
And that was brought to our attention, or to my attention, by the Automobile Dealers Association and many of the car lots. People are actually sawing off the catalytic converters of new cars on the car lots and then selling them. It actually happened to my dentist with both his cars in his parking lot while he's gone to dinner with his wife.
Okay.
And there's apparently quite a bit of money involved in recycling those.
Well, I have no problem with the amendment, but I want to make sure we are voting on 887.
That's correct. That's the one we're working from.
He's making changes on 884.
Well, the reason why is because 884, that subsection B, was basically
I mean, a couple
picked
of
up out of
sentences were,
884.
but I don't want us to assume we're transposing.
Does everyone understand what we're doing? 884, the lines 56 through 64 have been moved into 887 now. Okay. Representative Lunsford has made a motion to amend. Is there a second? Okay, we have a
Lines
motion and a
56
second.
through 64.
Correct. Lines 56 through 64 of 884 have been moved into 887. That was
61 through 64 have nothing to do with catalytic converters or.
I think they were in.
There's some additions in there that aren't in 887.
I think that he was to have consistency. He was inserting or catalytic converter after every instance of copper property. Okay. Let's see, Representative Everson, he waves. Representative Setzler.
To the author of the amendment, it seems like every 2 or 3 years we come back and add something to a bill because criminals have thought of new things to steal or new ways to commit crimes. Is there a way we can capture catalytic converter, be a little bit more general with respect to automotive or equipment parts of substantial value, something like that? That captures catalytic converter, but also catches the next thing they're going to start sawing off that's not specifically provided for the law. And again, I have to believe that they're not going to stop at catalytic converters.
Okay. Representative Knox.
I think there's already a crime in the code having to do with auto theft that includes the theft of auto parts. And I think that catalytic converters very likely be pretty sure that they would be covered under that code section as an offense under the code section of auto theft. in addition to that, I think there's a problem with the use of the term catalytic converter, because catalytic converter is not a thing. A catalytic converter is a process, and we have different devices that do that. Some are on vehicles and some aren't on vehicles. And so to the extent that we're trying to get at automobile catalytic converters, seems like we ought to leave that up to the code section that's already in existence, so we don't cause any conflict with that in this code section. We could do that, but you're still going to be saddled with the requirements of the code section with regard to automobile theft and automobile parts thefts, and those have different punishments and fines and so on.
Okay. Representative Abrams.
I will say that my seconding of this amendment was because I believe that the intent is narrowly tailored to say that if you steal this, you can only if you steal it and you attempt to sell it. If you try to make more than $25, it has to be made by check, and therefore there is now a record to track who receives it. I think that this is, well, I certainly understand both Representative Setzler and Chairman Knox's concerns, and certainly would understand better specifying what constitutes a catalytic converter. I don't believe the intent of this is to expand exponentially the number of items that are covered under this provision. This provision is simply designed to change how payment is rendered. It is not designed to change the auto theft, the underlying auto theft law. You have two separate sets of laws. One is designed to capture theft. The other is designed to create a tracking system that requires that when payment is rendered, that payment has to be tracked in a certain fashion. And I think that it would be a bit of an overreach to try to make this more expansive and cover any part that is stolen from a car, because you are, I think, conflating. I think that conflates two separate bills, and more importantly, two separate intentions of the law.
Ms. Travis, we are now using the language that talks about $100 or less. Is that
$25?
Is it $25?
Yes.
Okay, that was the second Knox amendment.
That was all part of the first.
All part of the first. Okay. Okay. Representative Levitas.
I have two on. First is a parliamentary inquiry. If you could define for me what conflates mean. I never learned that at UGA. That's a Yale word. I don't know what that means. And I know I'm just a country farmer from North DeKalb, but I thought a catalytic converter was in fact a thing. Catalytic conversion is a process, but a catalytic converter is a thing, is it not?
That's my understanding.
Okay. Thank you. I'll go back to plowing the fields.
Representative Setzler.
Mr. Chairman, I don't want to belabor the point. I don't know why we wouldn't say copper property or automotive part of substantial value. This is the last time I'll say it. I just think narrowly tailoring catalytic converter into this bill would be short-sighted. But I would just ask the distinguished lady from DeKalb to help me phrase something potentially. And if not, I just to the author of the amendment. You've thought about this perhaps a lot more than I. It just seems so narrow as to. I mean, are there not other things that are stolen that are going to be turned in that are going to draw more than $25, and we'd want to track as well, or is that just not the case?
Okay, Representative Abrams.
Having become a new expert on this issue, and I'm not an expert, I've written a book where I dealt with catalytic converter stuff. But anyway, so Mr. Levitas is absolutely correct that the converter is actually a thing, and I think you should. I believe that further defining this as an automobile catalytic converter is inappropriate. It's the metals that are used in a catalytic converter that have made them more attractive in this current economic climate. I think if you expand this to include anything on an automobile of value, I was going to use the word vitiate, but for Mr. Levitas, you ruin. If you expand this, I think you ruin the intent of the bill, which is to address a very specific set of crimes, which are to steal certain metals that have increasing value and attempt to recycle them and to gain funds from following a legal recycling process. I think expanding this to cover any part of a car is an overreach for this bill and is not necessary.
I'm sorry. Go ahead.
Is the issue in the definition, again, I apologize for not having raised this earlier, or any item composed completely of copper, is the completely not better addressed with substantially of copper, so that if there's a substantial copper value with only incidental or relatively insignificant other materials, is this going to exclude certain items?
Representative Abrams,
I
you seem to be answering.
Sir, this is
these.
not my bill. But I respect the author's intent. The author's intent is to capture a very specific set of crimes that are currently being committed, and those crimes have increasingly led to death and to harm to individuals. I think that you undermine the intent of the bill to try to overreach in your capture, but I also think that, to Mr. Setzler's concern, I think that catalytic converters are made of a different composition of metals than simply copper, and I think we would be getting into chemistry and metallurgy to try to identify what those things are, and so would strongly urge that we leave the bill as it's been amended.
My point exactly.
Representative Lunsford.
Thank you, Mr. Chairman. And to answer Mr. Setzer, I agree with you. It would be nice if we could legislate morality, but we can't. So what we have to do is punish immorality. And so what we're saying here is we're going to track the sales of thefts by someone who's recycling catalytic converters, and the person comes in 4 or 5 times with brand new catalytic converters to recycle. We at least have a paper trail. So I wanted to bring them under the same provisions. Is that going to prevent someone who wakes up in the morning and becomes a thief that's not going to steal? Probably not. He may just take them to multiple recyclers. But if he's also stupid and a thief and takes them all to the same place, we have a check and we have identification, etc. It has become a major problem in the Auto Manufacturing Auto Dealers Association, and we're just trying to capture some of that. Can we get everybody that creates a crime? And no, we can't. But without messing up Representative Williams' bills too much worse than we already have, I would just ask the committee to include the word catalytic converter, and then we could move on from there.
Okay. Representative Bearden.
Representative Lunsford, I support you 100%. I was just going to ask, to help to get this bill out today, would you maybe be in the mindset of removing that motion and work with the author and the Senate carrier to get that in there, and then maybe just make it sure it's taken care of in the conference committee report? It's completely up to you, though. I'm loving to hear your answer.
Pardon me? Yeah.
There's still work. I mean, you guys can't pass out a clean sub. I still got to put these together.
Mr. Chairman, if I haven't worked over in the Senate. Last year they allowed me to hawk over there on 2 bills, but somebody copped an attitude about it. So I don't work over there very often, although Balfour did let me vote in rules last year, which was kind of fun. But, with all due respect, I don't want to hold up Representative Williams' bill. Mark is a good friend, but at the same time, I don't think just the word catalytic converter is going to do that. I think those who would vote in favor of this are going to vote in favor of it either way, whether it says catalytic converter or not.
Not opposed to the amendment.
And I was under the understanding he wasn't opposed to that amendment.
All right. Representative Ramsey waves. Okay. We have a motion on the Lunsford amendment and a second. Representative Knox.
I don't have anything on this motion. I do have another motion to offer, though.
Okay, we'll come back to that one. Any further discussion on the Lunsford amendment? Okay. All those in favor of the Lunsford amendment signify by saying aye. All those opposed?
No.
Okay, we'll take a hand count. All those in favor, please raise your right hand. Okay, all those opposed? Okay. All right, the Lunsford amendment passes. Representative Knox, we'll recognize you for another amendment.
Thank you, Mr. Chairman. My amendment is at line 45 through 48. I'm sorry, I'm looking at 887S.
All right. Online, I'm moving to strike beginning after the number 9 and capital A. Strike detailed written description from the person receiving consideration in the purchase transaction describing the source from which he or she obtained the regulated metal property together with, and then striking all of that and then adding dated and time-stamped photograph of the purchased metal property, retaining that sentence. So the paragraph 9 would read, a dated and time-stamped photograph of the purchased metal property. Simply offering that in lieu of having to make a written description of the same thing you have a photograph of.
Okay. That's a motion, Representative Knox?
Correct.
All right. Is there a second to that motion?
Second.
Second by Representative Franklin. All right. Discussion. Representative Lunsford.
Thank you, Mr. Chairman. Representative Knox, are you under the impression that a man who would, or a woman who would actually steal it would have any problem lying on a detailed explanation of where they stole it from? So the photograph should suffice rather than a detailed explanation?
Although I don't have, but yeah, I'll just go with that.
Okay. Any other discussion on the third Knox amendment? That's 3, right? Okay. All right.
Mr. Chair, does the author have an opinion on this?
I think if I had to choose between the two, the photos would have won. And I think I agree with Representative Lunsford. They'll lie. So I do want the time dated photo.
Representative Ramsey.
I think Representative Everson raised a good point the other day on this issue where municipalities that have recycling that they're taking donations in, and then they're going to the secondary recyclers and selling them, and it might put some municipalities in a difficult position. It creates a little bit of ambiguity doing that detailed written description because they're not getting consideration, so the person that's bringing it in is not subject to these requirements to provide a detailed written description. And when they go to sell the metal, they're going to have a difficult time complying with that because they're not going to know where all these donations came from. So,
okay. Representative Everson.
Thank you so much, Mr. Chairman. This past Saturday, I spent about an hour and a half at Snellville's Recycling Center following the process. They're secondary. We take and accept donations from citizens in the city that are willing to get rid of their discards, refrigerators, ovens, etc. We don't pay them. We in turn turn around, we have a contract with Newell Recycling in East Point. However, there are facilities in Gwinnett County, across the state, that do allow citizens to come in and sell their discards. Are we asking those centers to keep a copy, a ledger, log of everything that's being brought to them on a daily basis? It's huge. It is massive. For everyone that's coming in, copper, metal, you name it, everything comes through. And Gwinnett County has one of the largest, if not the largest, recycling centers. We purchase anything from aluminum to you name it. It's coming through there. So I just want us to be very, very careful. Very, very careful with this. I'm sympathetic. I understand the problem we have. The farmers, I was talking to a firefighter in Gwinnett County. They're going so far now as to even steal the aluminum chalk blocks for the fire engines and selling those. Stormwater plates, etc. So I just want to raise that as a concern. Whatever we can do to lessen the burden on those that are in operation for making money and not putting too much of a hardship on them.
Thank you. All right. Any further discussion? Where are we now? We're the third Knox amendment. Okay. We'll go ahead and proceed with a vote on that. All those in favor of the third Knox amendment, signify by saying aye. Aye. All those opposed? No. The ayes have it in the opinion of the chair. That amendment passes. Just 2 noes. Now we'll proceed on to a vote on the bill itself. We have a motion do pass on HB 177 by substitute as amended. And we are again working from LC 3708887S as amended. We have a motion and a second. Is there any further discussion on the bill? Seeing none, we'll call the previous question. All those in favor of passage of HB 177 by substitute as amended signify by saying aye. Aye. All those opposed?
No.
1 no. The bill passes.
Mr. Chairman, if we could we make a special duty to get it to the rules before 5 o'clock? Jill has to turn it around.
Jill's got, she's going to have to put it in final form. Good luck. We're adjourned.